One of the most common questions people ask is, when is Amber Heard going to be charged with perjury? So let's talk about it. Part of what made Morgan Tremaine's testimony so powerful and so damaging is because he really hit the nail on the head when it came to nailing Amber Heard down in a lie, something that can potentially support a perjury charge. I think it's common for people to wonder, how can somebody get away with impunity, just making things up, changing their stories, giving these accounts that are obvious fictions, do this on multiple continents and not suffer any consequences for it? So let's talk about the practical reasons and the legal reasons. The practical reason is that the decision to charge Amber Heard, that's a political decision, as ultimately all charging decisions by prosecuting attorneys are. Prosecutors are elected officials. They are there to cater to their community, to represent their community's interests. And so a particular prosecutor may have a perspective on whether or not it's in the interest of Fairfax County to try to haul Amber Heard all the way back over to deal with how she behaved in the Depp trial in their courtroom. They may think that that's not really worth their effort, that they're ready to be done with it, or they might be, kind of outraged and offended at how this case really shouldn't have gone to trial in the first place, and this person should maybe suffer some consequences for taking up all of this court time, all of this effort to tell these stories that are such blatant fabrications. So that means it's really up to this guy right here to decide, is he going to pursue this or not? Does he consider it worthwhile or doesn't he? Now, Virginia has an added layer as well, where if you're not basically arresting somebody, in the immediate aftermath of committing a crime, then you have a grand jury process to go through as well. You have to get an indictment. So this would require this prosecutor to basically get his evidence together, present it to the grand jury, and establish probable cause to believe this crime has been committed. So there's plenty of reason to think that Morgan Tremaine's testimony would give him what he needs. So let's look at what Virginia requires in order to charge somebody with perjury. So one thing that's interesting about Virginia is they actually have two perjury statutes. There's two ways you can do it. We're going to look at the second one first because we're going to move on from it. And that statute basically just says, if you testify in one case about one thing, and then you testify in another case about the same thing, but give a different account, that is basically perjury on its face. You have to show that they did it knowing that they were changing their story, but you don't have to show which version was the true one, which version was the false one. It's enough to show that they changed their story. So I bring this up mainly because it gives us some insight into why Amber testified the way she did. Given the fact that she had already testified under oath in the UK, it was very, very important for her to stick very closely to that account she had already given in quite a bit of detail. And so some of those details, as we saw in the UK, didn't really pan out. They were fairly easy to go through and undermine with some additional evidence. So she needed to make some changes, but she couldn't do that overtly without running afoul, potentially, of the statute. So this is why Amber changed her story mainly by making it more ambiguous. She was much less specific about the dates of things that she described. and kind of how things happened, how things unfolded. This is basically a way to make it so that her story was more slippery, much more difficult to impeach with specific evidence, but not such an obvious contradiction from her UK testimony that she's potentially on the hook for perjury. But what Morgan Tremaine's testimony set up was perjury under this other statute. And that one says, if any person to whom an oath is lawfully administered on any occasion willfully swears falsely on such occasion, touching any material matter or thing. And if you do that, you are guilty of perjury, punishable as a Class 5 felony. So let's break that down real quick, what exactly that means. On the person willfully swears falsely. So willfully is a mental state requirement. That's essentially equivalent to an intentional, a knowing, a purposeful action. So it's not just that you said something inconsistent or you said something that's not accurate, it's that you did so on purpose. So it is important to bear in mind that that is something they have to show in order to support the charge. And then touching any material matter or thing. So materiality is a requirement of a perjury charge. If you just lie about what I was wearing that day, or sometimes even what day it happened. For example, if, Johnny Depp had beaten Amber Heard, it wouldn't really matter necessarily if he did it on a Tuesday or on a Thursday. So if she changed that, it isn't necessarily going to support a perjury charge unless that change is important. So Virginia has looked at some cases to evaluate these requirements as well. So in this particular case, going back to 1884, the court looked at this question of materiality. It involved a charge of stealing bacon. And so the question was it material whether the bacon was stolen on November 15th or sometime in December of 1875? And so under the particular facts of this case, what really mattered is simply whether the theft occurred or not. And so because it doesn't make it not a theft, if you did it on Tuesday versus on Thursday, in this particular case, that false statement, the discrepancy between the timeframes was not material. So it would not support a perjury charge when testimony in one case gave one date, testimony in a different setting gave a different date. This does open up a question, could that be material? And I think the answer to that is yes, it could be material if, for example, you say it happened on November 15th and the person had an alibi for November 15th. And so then you change the testimony to December. Under those types of circumstances where it is putting the issues in dispute into play, the credibility of the parties, which one here is telling the truth, then there's a lot greater likelihood that that type of misstatement or change in your account is going to be considered material than if it's simply, I said it happened this day one time, I said it happened this other day another time, but that doesn't really affect anything that is going to be part of the jury's consideration. So then there's a more recent case here from 1980 that deals with a driver's license suspension. And the issue in this case is that the defendant had made a sworn statement that he had not received notice of the suspension. And so in that particular case, the court, the prosecutor was able to present evidence of an order of suspension that, according to them, had been provided to the defendant, which would mean that he knew he was under the order of suspension and his statement that he hadn't received it would be false. And so in that particular case where the defendant is charged with driving on a suspended license, then that lie is absolutely material. One of the things that the state has to prove is that he knew his license was suspended. If he hadn't received the order, that's a defense. He's saying, I didn't know, therefore this wasn't a willful violation of the law. And that goes to the heart of whether he can be convicted of the crime or not. So that's a situation where they can prove not only is this something that matters, this affects the integrity of that underlying criminal charge because you lied about a fundamental element, but also that it was done knowingly, that if you had received this order of suspension, you knew perfectly well you had received it. So for you to testify that you had not received it is simply false and intentional. So let's apply that to the situation that we have here. The difficulty in a lot of these cases is always the proof, the evidence, and being able to show not just that something false happened, but that it was deliberate. And one of the ways that Amber Heard has been very clever with her testimony is being able to kind of make it not so factual, make it matters of opinion, matters of perspective, or this is just what I thought, or not her truth, not the truth, but just characterizing it in terms of her truth. And so that's very difficult for a perjury charge because perceptions, can kind of be anything. It's hard to disprove somebody's perception, but something that is very falsifiable is ripe ground for something like perjury. And so that's where Amber Heard's testimony that she wasn't involved in leaking the video, she didn't know anything about it, she wouldn't even know how to do that. These are statements that can be and were falsified by Morgan Tremaine's testimony. So by showing that TMZ had acquired the copyright, they could only have done that from Amber Heard, that is a direct contradiction, a falsification of her claim that she knew nothing and had no involvement in it. So right there is a big hurdle that has already been cleared to being able to establish the charge. You can show that it's knowing, because if she had to sign over her copyright, then that is something that she would have been aware of. Just like the guy with the driver's license suspension got the order, would have known he was under a suspension. And you can show that it's false and that it's material. Her arguing that I didn't leak this video, I couldn't have leaked this video, is at the heart of the hoax. She's trying to deny that this entire situation was fabricated by her for purposes of extorting a divorce settlement from Johnny Depp and elevating herself as, a noble victim, somebody who can pursue a career as an activist speaking on behalf of people that she despises. So the fact that she lied about one of these activities that she engaged in as part of the hoax, as part of the smear to make Johnny Depp look like a wife beater, that is, I think, arguably pretty material to the underlying question of, is it false and did she defame him? So we can show the elements of perjury. We still, though, have a little bit of a challenge in that it's a circumstantial case. We don't have her name on a piece of paper. We don't have an email from her. We don't have her voice on the telephone saying, I'm going to go ahead and give you the copyright to this video. Now, cases can be and often are proven entirely with circumstantial evidence. But it's not really the strongest position to be in. It's definitely preferable to have something unequivocal and definitive to support your accusation. So then the question is, look, this is a prosecutor. He has powers of investigation. A grand jury has powers of investigation. They can subpoena, they can call witnesses, they can do the same types of things that often a court can do to get information. So why don't they just go get that information from TMZ? If Amber Heard did sign over her copyright to TMZ, that's going to be in writing. They're going to have that documented. It's a transfer of interest in property. And so it's not real estate. It doesn't officially require a deed like a real estate transaction typically does. But nevertheless, it's something that you're going to document to CYA, make it crystal clear there's a paper trail, there's been a transfer here. So without a doubt, if Amber Heard signed over the copyright, her signature is on a piece of paper somewhere saying she is transferring the copyright to TMZ. So why can't we just go subpoena that from TMZ? Well, here's where we're going to run up against California's reporter's privilege. So several states have reporter's privileges. Not all of them do. And this came up when the attorney for TMZ was arguing to try to keep Morgan Tremaine from testifying in the first place. And he's trying to argue First Amendment bases for keeping him out. And the problem with that argument is that the First Amendment protection for reporters and their sources is extremely limited. It's basically because the First Amendment does not treat reporters really any differently from anybody else that states have then themselves gone and adopted these specific protections. And so in that argument, we saw him using the Virginia reporter's privilege to try to justify his position. Judge Azcarate did not buy that because the Virginia reporter's privilege is very narrow, applies to criminal cases. This is obviously not a criminal case, so he had to try to turn it into a First Amendment issue, which was inevitably going to fail. So Virginia's statute establishing a reporter's privilege to not have to disclose their source is pretty limited. But California's is extremely strong. In fact, it's so strong that they have gone and put it in their constitution. So this is not just a rule of evidence that can be overcome, a statute that can be modified. They have to go change their constitution now if they want to change the type of protection that they've given to reporters. And so let's look at what exactly their protection is. A publisher, editor, reporter, or other person connected with or employed upon a newspaper, magazine, or other periodical publication, or by a press association or wire service, or any person who has been so connected or employed, shall not be adjudged in contempt by a judicial, legislative, or administrative body, or any other body having the power to issue subpoenas, for refusing to disclose the source of any information procured while so connected or employed for publication in a newspaper, magazine, or other periodical publication, or for refusing to disclose any unpublished information obtained or prepared in gathering, receiving, or processing of information for communication to the public. So, unlike the Virginia statute, this one is extremely broad. Really, the only thing that's narrow about it is who gets to invoke it, right? They have certainly defined their protected class here with some care. So you have to have this connection with a newspaper, magazine, etc. Later on in the section, it also talks about news or television connections. So Some question about, random internet journalists, people along those lines, being able to invoke this type of thing. If you're not part of the press cabal, then you may not get to invoke this. But once you're in that club, you have an extraordinary amount of information that you get to keep to yourself and that you can't be penalized for refusing to disclose. So the important thing here is that it's not just the source, not just the identity of the source that's confidential. It's also this any unpublished information obtained or prepared in gathering, receiving, or processing this story for publication. So that's going to squarely encompass anything having to do with the acquisition of the copyright to the kitchen cabinet video. California courts have made it perfectly clear that any unpublished information literally means any unpublished information. That is so open-ended. It's so broad. There's very little that it's not going to cover. You made a phone call, you got a text message, you have phone records. I mean, you talk to somebody, anything that didn't make it into print, into your final draft, you're not going to be required to disclose it under this provision. So ultimately, this right here is, in my opinion, the reason why, even though Morgan Tremaine really teed up probably the best case for perjury that we have with a statement that is so falsifiable, so demonstrably untrue, and so material to the hoax, we're still probably not going to see it happen. And the reason why is because without her name on that piece of paper, it's not that you can't prove it, but it's just not your strongest case. And so when you have a political animal like a prosecuting attorney who's in charge of making that decision to go forward, it's just not enticing to do that if you don't have a real slam dunk case that gives you your best assurance that you're going to win that thing. Now look, I'm a criminal defense lawyer. I don't normally advocate for people to be charged with crimes. It's really just not what I'm about. But I have to say, our justice system is built on the premise that it has some kind of integrity, that the right people are being prosecuted for the right crimes, that victims are being vindicated in the courts, and that we owe the institution some respect. So when you have somebody like an Amber Heard, who takes up 6 weeks of the Fairfax County Court's time in order to tell lies on the stand, in a case that never should have gone forward to trial, if that goes unpunished, it just lets a massive amount of disrespect for the system go unchallenged. And I think that's really unfortunate in an era, particularly where people seem to be increasingly losing faith in some of our basic institutions. So I hope this is something that the Fairfax County Commonwealth Attorney will take seriously. Although, for the reasons we've talked about in this video, I can't say I'm optimistic that we're going to see a charge. But I do think that the hands-off approach that prosecutors in general have a history of taking with perjury types of charges, that may really need to change if we expect to rebuild faith in the institution of the justice system as something that is producing the right kinds of outcomes consistently. Because otherwise what you see is the system that Amber Heard believes is true in her mind, which is simply that she can get away with things and other people can't. Thank you for watching this series. I hope you've enjoyed this look at Morgan Tremaine and the incredible value that his testimony brought to making the case that Amber Heard is a big fat liar. So if you enjoyed this series, please like and subscribe. Stick around. I will be looking at other witnesses, other aspects of this case in more detail. And so if you've enjoyed these deep dives, there will be more, and I will see you there.